Well, welcome everyone. We are going to launch today's webinar on rentals, Airbnb, and managing transient accommodations during COVID-19. Very fun to have Lisa Mackey with us here today from Alexander Holborn. She is a lawyer and she does quite a lot of work really with rentals and helping with the kind of landscape of what both the Strata Corporation and landlords have to deal with respects to rentals in their properties. So thanks, Lisa, for joining us. This is really quite wonderful.
You're welcome.
Again, acknowledging and thanking BC Housing for their ongoing continued support of public education, which is so crucial at this time more than any other time whatsoever. Just to remind people that this week's sponsor are Grime Fighters. They do an excellent job at removing graffiti and damage to exteriors of buildings and garages and parking doors and those areas. So certainly give them a call if you are ongoing with a problem that needs to be addressed. The webinar is recorded. If you submit any questions, please do it through the Q&A. Please do not give advice to other people with respects to the chat division. Oftentimes, any information provided is less than sufficient to provide reliable responses, to which we encourage people to follow up with an email afterwards. For your privacy and protection, do not identify your strata plan or your business or personal information during a webinar. We'll hold questions to the end, as we have traditionally done. I'll try and group them together in topics so we can capture as many answers as possible, and we'll stay live right until 1 o'clock. And speaker email addresses are on the slides. This slide presentation, as well as this video, will be posted to the CHOA website later today and to the CHOA YouTube channel, so you can view them again and again and again. So here we go, Lisa, right into the basics.
All right, thank you, Tony. Thank you for having me. Welcome everybody on this Lunch and Learn session today. So we'll start with the basics first in terms of our buffet line of discussion. The Strata Property Act allows your communities to pass bylaws that limit or restrict or prohibit the number of residential strata lots in your communities. So notice I said residential. So the Strata Property Act doesn't bend as far as to allow communities to restrict commercial strata lots, but residential is permitted. You're allowed to pass a bylaw that includes a limit on the number of residential strata lots that are permitted in your community. And the limit can be administered in a couple of ways. The first is to limit the number, and the second is to limit the percentage. More often than not, it's the number that's limited, because that's a little bit more easier to administer in a community. You don't need to bring out the calculator to calculate the percentage. If you have a rental bylaw that restricts the number of residential strata lots in your community, then the bylaw, in order to be enforceable, needs to include a protocol for how those limits will be administered. So will the council have a waiting list? How will those on the waiting list be managed? How will the waiting list be administered? All of those ingredients need to be there in order for a successful recipe on a rental bylaw. And I should say, when we're talking about rental bylaws and enforcing bylaws, just how the bylaws are passed are just as critical as what the bylaw says at the end of the day. So we want to make sure that our resolutions are properly worded, that notice is given for those bylaws, and that'll make our job easier when we have a rental bylaw to enforce later. We want to make sure it's enforceable. There are exceptions to every rule, and rental bylaws are no exception there. So there are three main exceptions under the Strata Property Act. The first is family rentals. And so if the rental is to a spouse, if it's to a spouse's child or parent, or if it's to the owner's spouse, child, or parent, then those are exempt from rental prohibitions or restrictions. Renting to your uncle, your cousin, that's not going to qualify for the exemption. So the law is quite limited in terms of who's our family, and we might want to limit who's our family as well, but the law is very clear with respect to rentals. Hardship exemptions. So you as a council might receive a request for someone to be exempt from a rental prohibition or restriction on the basis that it would be a hardship for them to comply. And so if the council decides that the person has met the hardship criteria, then the exempted hardship rental would be exempted from the application of the rental bylaw as well. And then we also have owner-developer exemptions as well. So our owner-developers will have rental disclosure statements. If the owner-developer has put in specific language in a statement that would enable rentals, then there may be an exception to the application of the rental bylaw as well. Okay, hardship exemptions. Well, there's a reason why they're hard, and unfortunately, the pandemic hasn't made anything easier. So something to keep in mind when we're looking at rentals and strata corporations is the corresponding legal updates that have happened to the Residential Tenancy Act. And so I want to introduce you guys to Ministerial Order M089. It's been on our books for a while. If you Google Ministerial Order M089, you'll get a direct link to that order. And it has a significant impact for anybody who is seeking to apply for a hardship exemption from their strata corporation. So keep in mind that people will often apply for an exemption to the strata corporation's rental bylaw on the basis of hardship because of the financial strain involved with not allowing the property to remain vacant, for example, and not being permitted to rent. Well, what Ministerial Order M089, which is still current and is subject to an amendment, I believe, in the coming weeks, but right now this is what we have on the books. What it does is it prohibits landlords from being able to evict their tenants for not paying the rent. That is a significant hindrance for an owner if they feel that renting their property is a way to supplement their financial circumstances. So the law as it stands right now casts an embargo on evicting your tenant for not paying the rent. So anybody who is thinking of applying to their council for a hardship exemption should really think carefully, because in the event the tenancy doesn't work out, right now there's no guarantee of an eviction. Right now, under the order, there's also no ability to evict a tenant for bad behavior. So if you have the unfortunate circumstance of bringing in a tenant into your strata lot that causes damage, that violates bylaws of the strata corporation, under the ministerial order, unfortunately, landlords are prohibited from evicting tenants for that reason. There are special exceptions right now that the government has allowed with respect to security evictions and safety related evictions, but they're very, very narrow. And so the bad tenant scenario, unfortunately, has been put on hold. So something to very, very much consider when applying to your council for hardship. It might be even harder at the end of the day, which is something you want to avoid. So as I mentioned, owner developers can enable an exemption straight out the gate. For strata corporations that were filed and operational before January 1st, 2010, any exemption or allowance in the rental disclosure statement for a rental would pass to the first purchaser. So that is the purchaser who purchased the property directly from the owner developer. They would be exempt from the application of a rental prohibition or a rental restriction, assuming that that rental disclosure statement was filled out properly. For strata plans that are filed and strata corporations that are operational after January 1st, then that exemption is actually broader. It applies for the period of time set out in the disclosure statement, and it applies to all future purchases as well. So not limited to that first purchaser. All right, counting rentals. Well, if you are administering a rental limit, then you need to know that your math is correct. And so if you're a strata corporation that has a rental limit, for example, for the number of strata lots, then when you're counting the number of rentals in your community for the purpose of disclosing it on a Form B information certificate, then you leave, you have to leave room for the implications of that disclosure. So Form Bs expect you to disclose absolutely all of the rentals in the community, regardless of whether or not they would be enforced under your rental restriction bylaw. So remember that we said that family rental exemptions, hardship exemptions, and owner developer exemptions are not included with respect to the enforcement of your rental restriction bylaw. However, they do have to be counted for the purpose of disclosure on a Form B. And why do we want that? Because when people are buying into a community, they want a sense of how many properties are rented and how many are owner occupied, for example. So one of the things that I do recommend on a Form B, and there isn't really room there, the Form B is quite brief. It just requires the Strata Corporation to disclose the number of rentals in the community. To provide further information, you may want to explain the number of permitted rentals in the limit remaining. So that provides more information to the purchaser as well. So let's show our work and do a quick math problem. So say we have bylaws that limit a maximum of 20 residential strata lots at any time. So we might have 7 family rentals exempted from the provision. We might have no hardship exemptions permitted, and there might be 11 rentals permitted under a rental disclosure statement. But remember, those 18 exemptions aren't included in the tally for enforcement, but they are included in the tally for the Form B. So when we're filling out the Form B, if we do our math correctly here, we would have to disclose that there are 35 rentals. All right. Regardless of who you're renting to, you need to provide, the owner needs to provide a Form K notice of tenant's responsibility to their Strata Corporation within 2 weeks of renting the property. And so what is this document? So the document verifies, importantly, that the tenant has received a copy of the bylaws and the rules in the community. There is a commitment to abide by those bylaws and rules, so very important when we have rentals. It provides the Strata Corporation with the name and the contact information of the tenant, which is very important for bylaw enforcement purposes as well. And it helps the Strata Corporation with record keeping. So as I mentioned before, the math can get a little bit tricky when it comes to administering rental limits when there's certain exemptions. And so it's important to document all of the rentals in the community so that you know what to put on the Form B information certificate and you know who's who in the zoo, so to speak. And we all know stratas can be zoos at times. So short-term accommodations. Well, short-term accommodations are different. They're not rentals. It's not a residential tenancy that's covered under the Residential Tenancy Act. So what do we mean by short-term rental accommodations? We really mean temporary vacation accommodations, things for travel mostly. So Airbnb rentals, VRBO, they're not the strict rental or residential tenancy that a rental bylaw would cover. It's actually commercial activity. It's a business activity. And so if your strata community wants to prohibit those types of operations, there should ideally be a separate bylaw that covers that activity. There is an argument in the event that the municipality doesn't allow for short-term accommodations, and many do not. Some will require business licensing to be obtained from the owner, and of course there'll be a fee that's associated with getting that license. But in the event that it's prohibited in the municipality, then arguably that type of short-term accommodation would also be in violation of the standard use bylaws, so ones that prohibit illegal activity as well. But what's important to keep in mind here is your community is not protected against short-term rental accommodations if you do not have the proper bylaws in place that cover that activity. All right, so moving along. So the legislature has enabled us with the power to fine. And there's really good reason for this. So one is it acts as a deterrent. And that deterrent needs to be especially high when it comes to short-term accommodation bylaws, because as one can imagine, it can be quite a lucrative enterprise. And so under the Strata property regulation, the regulations allow strata corporations to increase a maximum amount of fines for rental bylaws to $500 every 7 days, which again isn't very much, but that's what the government allows us to do at this point. Short-term accommodations are allowed to be fined up to $1,000 per day. So definitely more cost prohibitive there. And just a reminder again, the Residential Tenancy Act does not help you with respect to a short-term rental accommodation. Okay, special considerations with respect to COVID-19. So the COVID-19 situation has dramatically altered the way that rentals are operating in our province, and as well as short-term accommodations. So we have restrictions right now with respect to travel, requirements to self-isolate and quarantine. We have restrictions, which I'll get to a little bit further later, with respect to rentals, when a landlord can access a rental property when they can, and how they can show a rental property, for example. And so when we're talking about administering rentals and short-term accommodations, there are special considerations with respect to COVID. So in the event that somebody is running a short-term accommodation, for example, so you have a lot of transient folks coming in, it's clear they've traveled from outside of the province or elsewhere, it's clear they're violating our healthcare orders and directions with respect to quarantine and self-isolation. Potentially, we don't need that short-term accommodation bylaw to start bylaw enforcement or penalties here. It may be a violation of our use bylaws. So under the Strata Property Act, we get default sets of bylaws that, unless we amend them by filing an amendment with the Land Title Office, then we have these standard bylaws that are usually left undisturbed by most communities. And those prevent anyone from using the property, and that includes a strata lot, common property, common assets, in a way that creates a hazard, in a way that is illegal, in a way that unreasonably interferes with others. So as one can imagine, if your strata corporation has passed rules, and certainly our government has passed various orders with respect to navigating our communities and ensuring that we do so safely, in the event that there's a breach of those requirements, and potentially there's also a breach of your use bylaws too. So something to consider. A little bit later in the talk this afternoon, I'll chat about the rules as well that your community might want to consider that helps navigate the short-term rentals and the rental process with respect to using common areas. How do you regulate moving? How do you manage your common assets and common property in a way that keeps everybody safe? Bylaw enforcement. And so, assuming we have a valid and enforceable bylaw to begin with, and we want to make sure as a council that we enforce it properly too. And we needn't look further than section 135 of the Strata Property Act. It's a very short section, but it's so critical. So if your council is thinking about implementing a fine or commencing bylaw enforcement proceedings, have a read, have a refresher. The Strata Property Act says that before you can fine anybody, so that includes an infraction of a rental restriction bylaw or a prohibition bylaw, or a infraction of a short-term accommodation bylaw, you need to be able to provide notice of the complaint in writing, particulars of the complaint, which is a fancy way of saying details, so what happened, the what, when, how, who. You need to provide it to the owner of the strata lot. If it's a tenant that is the alleged breacher of the provisions of the bylaws, and you also need to provide the tenant with the notice of the complaint in writing and particulars, and that opportunity to be able to respond to the complaint in writing or in a hearing appearance before the Strata Council. And for a COVID-19 perspective, remember that our government has allowed councils more flexibility in holding these hearings. So we can do hearings virtually like what we're doing right now over Zoom. We don't need to hold it in person, particularly in the event that we can't maintain required social distancing. After those proceedings are completed, so after the opportunity to respond, then the strata would make a decision in writing and alert the owner or the tenant as to whether or not any fines or other penalties would be implemented. The tenant, as I mentioned, can be fined. So the Strata Property Act allows some flexibility with who to stick with the fine. If the tenant doesn't pay, then the owner is stuck with that bill. Now the owner or the landlord can sue a tenant at the residential tenancy branch in the event that the tenant breached a bylaw, and assuming that their residential tenancy agreement provides for recovery of that payment. But the Strata Corporation does have the ability to collect both. But remember that either or, if you're collecting from the tenant or the owner, you do have to remember to provide them with notice of that complaint and the opportunity to respond. If you didn't, then unfortunately you're out of luck and your fine is going to mean nothing. All right, can we apply bylaws or rules differently to tenants? Well, the answer to that is No. Tenants are people too. They have the same rights to use the property and access the amenities and the common facilities as owners do. I'll talk about a little bit more restrictive powers that a landlord can make on their tenants, thanks to Ministerial Order M089. But these rights are even more empowered when a landlord assigns their rights through a tenancy agreement or through an assignment under the Strata Property Act, which allows the tenant basically to step in the owner's shoes, to run for council, to do votes, and to basically do whatever the owner is able to do at the property. So keep in mind that in that case, the tenant is really the owner for all intents and purposes and is able to dispute fines by applying for dispute resolution at the Civil Resolution Tribunal. So we're going to be treating everybody on an equal playing field here. All right. Can we apply bylaws or rules differently to short-term rentals? Well, these folks are not treated equally. So individuals that have transient use of the property, they're not transferred any special powers under the Strata Property Act. So the Strata Property Act only allows those owners to bestow certain powers onto a tenant. As mentioned before, a person who occupies a short-term rental property is not a tenant, it's not a rental, so they don't get any special privileges under the Strata Property Act. And with the Strata Corporation's duties under the Strata Property Act to make sure that the property is repaired and maintained for everyone's best interest and meets health and safety standards, we want to make sure that we keep a keen eye on that transient movement at the property, which, as I understand, has unfortunately been a problem for many communities in BC who are detecting folks that are renting their properties on a short-term basis to travelers who are not quarantining or self-isolating. You're permitted to still, as a Strata Corporation, restrict the use of your facilities and pools, your gyms, your social rooms. And why might you want to do that? Well, because the Strata Corporation has the requirement to ensure that the property is safe to use and that it's repaired and maintained. And COVID-19 has changed the way that we can use and enjoy the property. And so as a Strata Corporation, we can limit movement in those areas. We can restrict numbers in those facilities, or we can frankly keep the facility room door closed. How do we control or limit moving? Well, the short answer is we cannot. So as a Strata Corporation during the pandemic, you are not permitted the ability to ban move-ins or move-outs. That isn't something that the government has enabled Strata Corporations to do, and it makes good sense because people would or should maintain that degree of mobility. You can pass short-term accommodation bylaws, as mentioned, that would prohibit VRBO and Airbnb style operations. And I would encourage Strata Corporations to look into those bylaws, particularly now, given the risks associated with transient populations moving in and out of Strata Corporations frequently. Although you cannot stop a move, you can regulate how a move happens. So Strata Corporations can establish rules that engage protocols for using elevators, for example, and scheduling and reserving use of common assets, hallways, having sanitation protocols, requirements on what movers should or should not be doing with respect to depositing property in the common areas. You can control the move, you just can't prohibit it. And so what kind of controls might we want to establish here? Well, one might be the time of day that moves are limited to, the number of hours that somebody can reserve an elevator for, particularly in properties that only have one elevator, for example. Regulating how somebody can use the common areas, so how many people can be assisting in the move, assuming that they cannot establish safe social distancing requirements. Implementing cleaning schedules. So what is going to be the Strata Corporation's protocol before and after a move? So when somebody has been moving their belongings in the hallways, for example, in the elevator, what can be done to safeguard those areas later. So what are the cleaning obligations on those moving? And what are those on the strata corporation after? You can establish rules right now that council can pass on their own by a majority vote. It does need to be ratified at the next general meeting by a majority vote in the event you still want it in the books, but it's a quick and easy way to start developing COVID-19 protocols when it comes to moving in your community, because rules govern the use of the common areas and common property and the safe and healthy use of those areas. Failing that, your community might want to consider bylaws as well. Keep in mind that you do, again, as a reminder, have the bylaws that regulate the use of common property and strata lots in a manner that complies with the law. So that would include any orders from our government and directives from our healthcare officials with respect to limiting the transmission of COVID-19. All right. I think we're on to the next slide. Next one after that. Perfect. Okay. So special topic just to close out. So we've been talking about rentals as if the owner of the property is one of the owners in your community, but sometimes a strata corporation will actually rent out the property. And so if that's the case, if your community has a rental property that you use, then you need to look up Ministerial Order M089. As I mentioned, it's currently still on the books today. There will be an order that expands a landlord's rights that is expected to happen later this month, so in the next few days. But for now, we need to be especially mindful of Ministerial Order M089. So what does that do? Well, as I mentioned at the front end, it prohibits certain types of evictions from happening right now. There's also a moratorium on rent increases. So usually once a year, a landlord's permitted to issue a rent increase up to the maximum amount allowable under the Residential Tenancy Act, but that order does away with that. So in keeping with the protections that are afforded to our communities as a result of the financial strains associated with COVID-19, tenants have been given special protections so that they don't encounter a rent increase when potentially they're under significant financial restraints due to loss of employment or diminished employment opportunities as well. Landlords are permitted to shut down common areas and facilities without having to compensate a tenant for doing so. So ordinarily under the Residential Tenancy Act, if you were to close a door on a facility that is otherwise provided under your agreement or provided the rental property, then you need to provide the tenant with compensation. So the government has recognized that landlords may not want to operate their gyms, they might not want to operate their social rooms, and there's good reason for doing so, i.e. everybody's safety and well-being. And so that ministerial order allows landlords to keep the doors shut and not have to compensate their tenants for that closure. There's also a moratorium on accessing a strata lot. So unless it's the case of an emergency situation, landlords are not allowed without their tenants' consent to go in and inspect the property for a routine condition inspection, for example, or to show the property to prospective tenants. So again, please do have a look at that order in the event you are renting your own property or in the event your strata corporation does. All right, I think we're on to the Q&A.
That's a great overview, Lisa. Thanks so much. Yes, we are on to Q&A, and the Q&A kind of has some interesting threads that are all the same, so this should make it kind of easy. One of the key questions people are asking is either with short-term Airbnb type things, or if you have the strata is permitting rentals, is the strata corporation permitted to charge the landlord an additional monthly fee to be able to permit them to rent the units or Airbnb?
No. So the only fees that strata corporations are allowed to pass along are user fees, reasonable user fees. I suppose you can make an argument that a reasonable user fee might be the additional cleaning charges, but in my view, it's just passing the buck in terms of what a strata corporation would be required to absorb in the ordinary course. So I would be hard pressed to say that any bylaw or rule would pass muster with the Civil Resolution Tribunal if challenged.
There's also a large number of strata corporations, especially those that have multiple stratas sharing community centers or joint facilities that have guest suites. And the guest suites are used by guests of residents of the property, in which they can charge a fee of whatever they're charging for maintenance and operation and use. The question is, are guest suites owned by the corporation for resident use the same as Airbnb? And really, what protocols should we be following for the management of the guest suites?
Well, if you're monitoring a guest suite, so for one, I guess the first question is, does your Strata Corporation even want to continue running the guest suite during COVID-19 pandemic? So it's a common asset of the Strata Corporation. It should be subject to specific governments for how individuals will reserve the guest suite. There's inherent risk when you're bringing outsiders into your community. So one of the things that our government has allowed councils to do is to limit the passage of individuals that aren't residents. So it's not offside, for example, to say, right now, we don't want to reserve this space for anyone outside of a household or a community for safety reasons. Presuming that your Strata Corporation has that guest suite and they're using it as a short-term accommodation situation, the first question for council, I think, should be, can we safely continue to run this guest suite? What protocols or additional protocols should we be doing with respect to use of the guest suite, cleaning protocols, for example? One of the guidelines to look for your Strata Corporation would be the WorkSafe guidelines as well. So WorkSafe BC has encouraged certain guidelines for hotels, and this is sort of the equivalent. It's a short-term accommodation. It's a useful resource to look at for building rules with respect to your guest suites. The Strata Corporation certainly maintains control over that. As I mentioned, with Airbnb or short-term rental accommodations, it's entirely within your community to pass bylaws that prohibit those activities, particularly now, given the risk of transient populations moving in and out. But I think I would strongly caution Strata Corporations before they continue to use a business as usual approach to their guest suites.
Well, this kind of applies to Airbnbs as well, because you really have to know the origin of where these guests are coming from. So if it's your mom and your dad coming over to Vancouver from Victoria for the weekend, trace contacting is pretty easy to manage. You can screen them in advance. The Strata Corporation should also publish screening protocols so that they're asking the right questions in advance of these of the guests coming into the building, interacting with owners. But what we're seeing is a trend and an increased number of complaints where there are individuals from outside the country who are using Airbnb accommodations, or they're guests of owners in guest suites, and they are required to isolate or quarantine for 14 days, and that's not happening. They're coming in for the 3 or 4 days of the Airbnb rental. They're interactive with the building, they're interactive with the community, and they're leaving, and there is no contact tracing that's being done. So unfortunately, the risks increase exponentially when that occurs without knowing the origin of where these individuals have come from and whether there's any screening.
Absolutely, and I think councils need to be hyper vigilant about that. So owners usually in a community don't like seeing that hoteling operation for security reasons. The topic of regulating short-term accommodations can fill up an entire lunch and learn, and frankly might make you want to lose your lunch. But the long and short of it is there's inherent risk already with allowing your community to be used as a hotel. So one is it changes the risk of the property. So usually our properties are insured for residential use only. There's an argument that these type of operations materially change the risk of the property to a commercial operation. So if your insurer of the property is not informed about that use, potentially if there's an incident, so a personal injury or property damage, you might not be having available insurance coverage at the end of the day. Before COVID-19, there were all of these risks associated with giving hoteling reserved guests fobs to access building or common area or facilities. And those risks are exponentially elevated by virtue of the fact that we now have a virus that is very, very harmful and highly contagious. And as Tony, as you were mentioning, without that ability to trace the origin and to zero in on who these folks are and where they came from, you're really exposing your community to risk of an incident in the building, which is something we obviously all want to avoid.
Yeah, and with the relaxed kind of social distancing, we have more relaxed protocols. People are being much more casual about an honor system of using the gym and the pool and things, which is just simply not going to work for anybody. It places everybody at higher risk. So here's another, actually, this is a really great question. I don't think we covered it. Can a tenant be evicted if the owner did not have approval from the strata to rent? So to start with, strata councils don't approve tenants. They permit the enforcement of the bylaws, and if there's a vacancy, they permit someone to rent. But strata councils cannot screen tenants or approve tenants. But the legislation actually does protect the tenant in this circumstance.
It does. So what it does is, in the event a tenant rents a property and they weren't actually permitted to rent the property, and usually those scenarios will happen when they discover that there is a rental prohibition bylaw or a rental restriction bylaw they weren't aware of. And so typically their owner or their landlord that is renting the property won't provide that Form K, Notice of Tenant's Responsibilities, to their tenant to have a look at. If they did have a look at it and signed it with the tenancy agreement, they would say, oh my goodness, I'm not permitted to be here. And so what the law allows tenants to do, in the event they learn they're not allowed to be there, they're allowed to break their lease without any repercussions from the landlord for breaking their lease early, and they're allowed for compensation. So they're allowed to get moving expenses up to 1 month's equivalent of rent. I also warn landlords, in the event that they are renting illegally, is they open themselves up for further liability. So in addition to the strata fining them for breaching the bylaws, their tenant might suffer additional damages that are beyond what the Strata Property Act allows them to get. So if a tenant can establish that they sustained additional financial losses by renting from a dishonest landlord, then potentially the dishonest landlord might be opening up their wallet even more.
There's a few questions on here about relating to the sublease of a room. So rather than renting to a tenant who takes full occupancy of it, can I have other people who rent a room, or can I share my accommodation? And I think most readers miss the definition within the Act that says that if a person rents a strata lot or a portion of a strata lot, and their bylaws really have to reflect this if they're going to be enforceable.
Absolutely. And it's that key word is portion. So, and that's unfortunately overlooked by a lot of communities. So they take the trouble of passing that rental restriction bylaw or prohibition bylaw. They miss out renting the portion of the strata lot, and their bylaw misses the mark. And so somebody says, well, I can sneak through because I'm only renting a room out. And so you want to make sure, if you do take the steps of passing these rental restriction bylaws or prohibition bylaws, that your bylaws prohibit exactly what the Act allows you to prohibit, which is, or restrict, which is renting portions of the strata lot or the entire strata lot. Something to consider from a landlord perspective: if you are renting rooms in your strata lot, then technically the Residential Tenancy Act won't apply to you. So that means that you can't govern that tenancy in a usual way. You're stuck, instead of going to the residential tenancy branch, which is an administrative tribunal, not unlike the CRT. It's meant to navigate disputes very quickly and efficiently. In the event you're renting a room, the branch isn't where you go, it's Supreme Court. And that is a very costly and time-consuming place to fight rental disputes, and some place to avoid. So there's additional considerations when you come to renting out portions of your strata lot that I think a lot of owners overlook too.
Yeah, no kidding. It wasn't part of our normal dialogue when people were writing rental bylaws, for sure. I think one of the points we should make for the listeners is that short-term accommodations are not rentals. They're commercial use of property, and they are not affected by a rental bylaw. You need a separate bylaw that regulates, prohibits, limits, whatever it does, the activities of short-term. If you want to have different screening requirements, different conditions, you need to include that in your bylaw with respect to your short-term accommodations. Rental bylaws under the Residential Tenancy Act are for tenancies that fall within the 30+ day period that become part of the residential tenancy. And I think that's one of the challenges, that people intermix rental bylaws and short-term accommodation bylaws. So we still see quite a lot of VRBO, which is vacation by rental, rental by owner, and those are still function, but those are still commercial bylaws for commercial use of property. They're not rental bylaws.
Absolutely. And I think what complicates matters, and I say it myself, I call them short-term rentals. And
we all do. Everybody does.
You know,
right?
we use that language, and it makes everything that much more confusing. But they're not the rental as we would consider the meaning under the Strata Property Act or the Residential Tenancy Act. And just to sort of add to what Tony was mentioning about drafting these specific commercial use bylaws, consider expanding your bylaw to prohibit the advertising of your property as well. So how do a lot of folks learn about a Airbnb or VRBO operation? They see it because their community is advertised and listed. And so if your bylaw is broad enough to say, it's a breach of this bylaw to even advertise the community as being available, then that is that much more stringent with respect to your governance of that operation.
Well, and everyone who's renting a short-term rental tends to gild the lily on a regular basis. So a 2-bedroom with a loft is often advertised as a 4-bedroom, and you end up with far more people occupying. You have the transiency issues, you have parking issues, security issues. It's very difficult to manage the safety and the security of a building if you have constant transient occupants moving in and out of the building.
Absolutely. It's hardly social distancing. Frankly, it's a house party.
Yeah, no kidding. No kidding. Did you have other thoughts that you just wanted to add? I'm just going to keep surfing the questions a bit.
Oh, absolutely. So I think one thing to keep in mind, just as we're on the short-term accommodations, is just because strata corporations have that power to limit or prohibit short-term accommodations or hoteling use of the strata lots, so too does a landlord. So one of the things that I encourage our landlord clients to do is to include the same type of restrictions that we would in a strata corporation's bylaw, which is you cannot use this property for a short-term accommodation. So one of the things that the Residential Tenancy Act is silent on is this very operation. It does say that a landlord is allowed to restrict assignments or subletting situations of their rentals, subject to certain criteria. But the Residential Tenancy Act doesn't actually mention short-term accommodations. And why is that? Because they're not rentals. And so the better protections for a landlord in their tenancy agreements would be to pass a term or include a term in your agreement that prohibits, again, advertising the property for being available for short-term accommodation and using the property in that way, and specifically saying that this is grounds to issue 1-month notice for cause in the event that you do so.
Yeah, it's kind of the ongoing challenge, isn't it? So here's another short-term rental. There, I said it. Okay, it's out.
We all do. We all do.
But another.
We should have a little rental jar, like a swear jar, where every time we use that, we'll put in 25 cents. Mine
would be full at the end of every day. But we'll just call it the Airbnb side. So sure. The Airbnb. And this is a good question, and I would think that under short-term accommodations, strata corporations can adopt very clear restrictions under COVID-19 for screening and who's coming and who's allowed to be in. Travel in BC is hotel openings are limited. Airbnb is still a viable option. Is it possible for the strata to consider an Airbnb bylaw that restricts Airbnb occupants with screening to only BC residents?
I think that there's no issue there apart from this legislation called the Human Rights Code.
Right.
So we want to make sure that whatever restrictions we have in place are not possible for being interpreted as discrimination under the code. So what does the code give us? So the Human Rights Code says we can't discriminate against somebody in a tenancy. This is not a tenancy, so we can scrap that protection. But it also says that we can't discriminate against somebody with respect to accommodation being available to the public or a service. And so if we are crafting those limits, what I might suggest is being very, very careful of the language so that we're very specific to this is COVID-19 transmission protection, that we're not saying specific nationalities, for example, or place of origin, which are protections under the Human Rights Code. So we want to be very specific that the residents of British Columbia are permitted, but we avoid language that might trigger those protections under the code. So that would be my only My only lingering red flag is that if we do expand on our occupancy restrictions, which I think we can, we just want to make sure that the verbiage that we use doesn't step on any human rights terminology.
That's wonderful. We've kind of exhausted all the relevant questions to the rentals.
Okay.
This was an excellent session. Thank you so much.
Fantastic. I feel kind of bad that my background doesn't actually reflect a proper Zoom background. So apologies to anybody watching this blank wall and behind me. I know that Tony is way more decked out than I am today.
No, but we can see you clearly and it's great sound and that's just wonderful. And just a reminder to everybody that we do post these to the CHOA website and to our YouTube channel. Please feel free to share the video and the resources with everyone else. On the CHOA website, there is a COVID-19 green bar. If you click on it, all the ministerial orders, all the guides, the references that pertain to screening, you'll find them all in sequence as they've been posted chronologically. So just scroll down through them. We've kept them all there. We haven't removed any so that you can look at kind of the history of what's going on as well. I think at some point we're going to have to start purging some of them just out of being dated or that there are too many. If you have any additional questions, you can email Lisa or myself directly, or you can email to info@CHOA and we'll make sure one of the advisors gets your questions. Next week's webinar is we're going to go in depth into bylaw enforcement in a whole bunch of ways. So we'll talk about all the great things like pets, people, parking, pools, and of course prostitution, because that's one of the 5 Ps. So we'll capture them all for next week. And then of course how COVID-19 has played a real role in how we're enforcing bylaws. There have been some pretty dynamic changes. So thank you again to everyone. Thanks to BC Housing and Grime Fighters, and we'll look forward to seeing you at next week's seminar.